So it's not so much that there's no law to apply, it's just that there's no law that we should be applying in this context. And so those two considerations, I think, are important to focus on when you think about this. There's a couple of other points that are worth making here, which is that there are exceptions. There's this footnote 4 at page 629 to 630 that says, we're not going to completely abdicate our role here, because if the agency refused to initiate proceedings based solely on the belief that it lacks jurisdiction, that's a legal determination. The courts can enter into that discussion. If it was a situation where it could justifiably be found that the agency had consciously and expressly adopted a general policy that was so extreme as to amount to an abdication of its responsibilities, then maybe we'd get involved. We're not saying for sure, but maybe we'd get involved. So there are these exceptions. And then there are these sort of other solutions that the casebook articulates at 633 to 634. There's other things that you can do. You can petition the agency to make a rule. And if the agency refuses it, by the discussion that you see from Massachusetts v. EPA on 632 to 633, you can challenge that. So that provides a mechanism to go into it. There may very well be arguments that there are other legal interpretations that are incorrect in the agency's decision not to enforce. Those you can challenge. You see the sort of other mechanisms that are out there at 633 to 634. You could argue that there's a private right of action that should be found in the statute. You just go directly against the individual regulated party. Or you can just take alternative mechanisms, go through political routes to try and get the agency pressured to take enforcement actions in this particular case. So those are all reasonable approaches that might be taken that allow you to get around situations in which the courts might otherwise be tempted to say, sorry, we're not going to review the agency's decision here because it's committed to agency discretion by law. Okay, so the last case to talk about briefly is Norton versus Southern Utah Wilderness Alliance. One of the lessons I think that you carry away from Heckler versus Cheney and the no law to apply idea is that you don't want to spend a lot of time talking about things with respect to which the agency has a lot of discretion, right? You don't want to say, oh, this is a matter of a policy choice, or this is a matter of something that the agency has a lot of room for analysis in, and it's just made the wrong decision. So you want to back it out some and say, look, this is a situation where the agency is responsible for behaving in a certain way pursuant to the statute. So that the agency is, by taking the overall approach that it's taking, it has failed to comply with certain statutory directives. You can get into a little bit of trouble, though, by backing away too far, because you get into the problem that you get into, or that the petitioners got into in Norton versus Southern Utah Wilderness Alliance. As Justice Scalia points out, this is a case in which the environmental group, the Southern Utah Wilderness Alliance, was challenging the BLM's policies, the way that it was managing lands in Southern Utah under FLPMA, the Federal Land Policy Management Act. And in particular, they were concerned about BLM's failure to step in and limit the use of off-road vehicles in southern Utah, and particularly in areas that were probably wilderness eligible. They hadn't yet been put into the category of wilderness areas, but if you left the off-road vehicles out of there, maybe they were roadless enough that you would say, yeah, that's something that can be used as wilderness. So they say, look, BLM, you violate the non-impairment obligation that says basically you shouldn't be impairing lands that can be used for wilderness. And in any event, you failed to implement provisions to limit off-road vehicle use. The main takeaways from this case, I think, are threefold. First of all, the language that you want to focus on as far as the holding of the case is the one at the beginning of the first full paragraph on 638. It says, a claim under Section 706.1, which is the one that says that you can sue an agency to compel agency action that's been unlawfully withheld, right? So the reviewing court shall compel agency action unlawfully withheld or unreasonably delayed. What you want to be able to do is that you can proceed with a claim under 706.1 only where a plaintiff asserts that an agency failed to take a discrete agency action that it is required to take. Okay? A discrete agency action that it is required to take. Now, this feels very much like the stuff that we're going to talk about next week, which is the standing rules, which says you can't come in and just say generally, look, we don't think that the agency has complied with the law. You have to come in and say, here is what it is that has happened that is in violation of the law, and this is why it has hurt me, and here's how I'm going to benefit as a result, court, if you rule in my favor. Okay? If you do it that way, then you're in good shape because you're identifying the link between the legal injury, the factual harm that you're alleging, and you're showing why it is that you're going to win as a result of victory in the case. If you don't do that, if you just say the agency was supposed to do stuff that they're not doing, that feels a lot more like you're just making a generalized grievance. And the courts don't like that kind of generalized grievance, and I should say especially Justice Scalia doesn't like that kind of generalized grievance. So the main focus here is articulating what discrete agency action the agency failed to take and what it was required to do. Now, frankly, could the petitioners in this case have done that? Probably. They probably could have accomplished largely the same thing and survived the challenge that was made in this case by just doing a better job of their pleadings. Okay? So one of the things that's worth taking away from this idea about agency in action is that you have to be careful with your pleadings when you're making a case for something that an agency has failed to do or that it should have done under the statute. The second takeaway is just when you're thinking about this, think about the remedy. And that will help you articulate the pleading in the most specific way possible. If the remedy is just we want the agency to comply with the law, that's not going to be good enough. You need to say to the agency, here are the legal provisions that have to be complied with, and this is what you're required to do as a result. Even if you might want to say the agency has some room for discretion, you need to nevertheless explain why it is that the agency, for instance, is required to regulate off-road vehicle use in this particular area. Okay? You may even want to focus in on particular areas to try and do that. The final point that I want to make comes up from the discussion of Track versus FCC at 641, this D.C. Circuit case. As the discussion of Heckler versus Day that immediately precedes that notes, the court is very reluctant, and really all of the federal courts are reluctant to impose absolute procedural deadlines on agencies if they can't be found in the statute. So if you've got an argument about unreasonable delay, it's going to be awfully tough to get the court to step in there and say, agency, you have to do something. That said, you can tell a good story about why the agency has delayed for too long. In particular, the sorts of things that you can do a good job with is if you point out why it is that the agency itself, for instance, has believed that this is a problem in the past, but it has failed to take steps to try and solve that particular problem. The other things that are going to matter is if there is some kind of a statutory outline that suggests that Congress was interested in a particular approach or a particular timing of an approach that the agency isn't complying with. You can make an argument that if there's health and human welfare at issue, or if there are irreparable injuries that are going to be suffered, you're going to require the agency, or be more likely to require the agency to act sooner rather than later. You have to think about what the competing interests are, right? What else is it that the agency is going to be left to do? If you're defending an agency in a case like this, you want to highlight the things that you're going to lose out on, the things that you're going to have to be preempting in order to comply with the relevant obligations that the court has come up with. So those are the main things that I think are worth taking away from these decisions. Thanks for putting up with the multiple pieces, which I've found I'm going to have to put this up in multiple 10-minute pieces. Thanks for putting up with having to sit here and watch me on YouTube. I'm sure it's not nearly the most interesting thing available to you at your fingertips, but I hope that this was useful, and at least it's helped us catch up. I should be back on Tuesday. We'll talk about some of the problems from the reading for today, and then we'll start moving on into Chapter 11 on standing. So thanks a lot, and I'll see you in a couple days.